Western governments accused Tehran of supplying Moscow with drones and missiles for use in Ukraine. Russia has regularly criticized Israel's operations against Iran's proxies in Gaza and Lebanon. The meeting's taking place in Turkmenistan during an event to celebrate an 18th century poet. Jonathan Savage, Fox News.
The Nobel Peace Prize was awarded this morning to a nuclear advocacy group in Japan made up of survivors of the U.S. atomic bombings that ended World War II.
About 114,000 survivors of the bombings are still alive. The Nobel Committee's chair said the award was made as the, quote, taboo against the use of nuclear weapons is under pressure. Efforts to eradicate nuclear weapons have been honored by the committee in the past, in 1995 and 2017.
That's Fox's Tanya J. Powers. On Wall Street, stock futures mixed, not moving much before the opening bell. In the baseball playoffs, the Yankees advance.
Line drive to right, that's going to drop for a base hit. Torres comes through.
Juan Soto gave New York the lead in the first inning, and they kept it, beating the Royals in Kansas City 3-1 on TBS. The Yankees don't know, though, who they'll play next in the American League Championship Series. Cleveland beat Detroit 5-4 to force a Game 5 finale in that series. On Thursday Night Football, San Francisco beat Seattle 36-24. I'm Dave Anthony. This is Fox News.
And Stan, we got to talking and missed our cue, so we are live on WDXE, and we of course have Estate Plan Stan. How are you this morning?
Good. Good morning, Charlotte. Good morning.
And yeah, you have me. I'm sorry.
No, it's all right. It's a pleasant surprise. I'm more than happy.
So you never know what you're going to get around here.
No problem. I guess you say spring break is everybody's spring breaking, so to speak. I know of Pulaski, the college is pretty dead as you drive through.
Oh, well, Jeff is still out, so, and then, like I said, we have several people on vacation around here as well, and
Gotcha.
so the only people that don't get a break are us business owners.
I guess. Yeah, but that's true. That's true.
So we're always working, so here we are.
Here we are. So, yeah, it's always good to be here. When Jeff and I always call this, I certainly call this the fastest hour of my week. Seems like I sit down for this show, and next thing I know, that the hour is gone. It just is amazing to me sometimes. But
It does. It goes by quick, doesn't it?
It does. Well, we always start off, I like to remind people of what I've got coming up. And I've got a seminar coming up on November the 2nd, which is a Saturday. And, of course, our Saturday seminars are done at 10 o'clock in the morning. And this one's up for our northern listeners up in Franklin. And we call it Will's Trust in the Nursing Home, and that's what we talk about. And its physical location is a place called Suite 501, and it has a physical address. If you want to come to that, you can put into your GPS. The actual address is 416 Mary Lindsay Polk Drive.
What's that close to? Because I live in Franklin, have no idea where that's at.
Well, it's kind of in the industrial area. I mean, it looks like a small mall, and it's got a lot of rental space. A lot of music rental space. As I roam around, I see rooms that are small. And
so is it close to downtown Franklin, like the square? Or
no, it's not too. I can get there. But where it is relation to other things. Where it is in relation to other places, I'm not sure.
Okay. Okay, so give me the address again.
It's 416 Mary Lindsay Polk Drive in Franklin.
I'm writing it down.
Yeah, you can Google it. It's a nice little venue. I mean, it's kind of limited in space, but usually has enough for our crowds. But it's a cute little venue. So anyway, I'll bring that up again at the end of the hour. So again, we always invite people to call in on the show and ask questions. I'm sorry, I was hoping to
just excuse us. We're
Should we be
playing around here. I'm just going to listen and see how we sound. But go ahead.
Okay. Well. This is a interactive show. This talk radio we do. We invite questions during this hour. Any subject matter is fine, or a life experience. As long as it's pertaining loosely to estate planning.
Well, I was going to say we can even talk about nuclear engineering, right?
Well, we could if I can remember any of that. So yeah.
And those of you that don't know, Stan is also a nuclear engineer.
I wonder if I still am or not. I guess technically it doesn't.
You blew me away when you told me that you were a nuclear engineer and went to estate planning. That's very interesting.
Well, I went to practice law in the first place.
You did?
No, I did. Well, I mean, I was an engineer for about 20 years before I went to law school, and I was in nuclear power, which means nuclear engineering sounds pretty impressive, but really just means we were generating electricity for one utility or another. And that sort of thing. So,
I still think that's very cool.
well, actually, one of the last places I was at was right down here in Decatur at the TVA facility.
Cool.
The Browns Ferry. So.
But awesome. Okay, so estate planning.
Yeah, that's right. So we do estate planning now.
So what got you into estate planning?
Well, I was practicing law for about 10 years before I got into estate planning. So when I started practicing law, I was doing mostly exclusively criminal defense work, which, I was a trial attorney, which was pretty neat because, it's exciting, a lot of rules, a lot of procedure. And jury trials are unique. The first one I had, I think I was scared to death, and after that, I realized that I wanted to do that for a while, And I actually did several murder cases or homicide cases, and actually became death penalty qualified, and was one of 30 attorneys in the state that handled death penalty cases, and actually had 2 death penalty cases. And so, stakes are high. It was interesting. I like being in a room full of people where I'm the only one talking and everybody has to listen to me. So that was great. But somewhere around 2007 or 8, and my mother passed away, and then my father passed away in 2010, and their estate. And they lived up in Pennsylvania, and their estate was going through probate up there. And I have my youngest sister, my youngest sibling, my sister was the executor of that estate. And so I would call her from time to time, or vice versa, and just kind of say, how's it going? What's going on? And it became kind of cumbersome. And it took like 2 years and 4 months to get through this probate. Now, Tennessee is a little more probate friendly than Pennsylvania, but it took over 2 years. And I'm not talking about a complicated estate. You'd think, well, if it takes that long, it must be all kind of
Y'all weren't fighting. She didn't say, hey, I'm going to hang this over your head.
No, not really any of that. It was my folks, had a house, some money in the bank. My dad dabbled a little bit in stocks. But other than that, nothing real remarkable, but it still took over 2 years. And so I actually spoke to the probate attorney up there and got a little angry with him because he just sort of blew me off and said, well, this is the way it goes. There's nothing we can do about it. So that sort of prompted me to look at how we do things here in Tennessee. And because I remember thinking to myself, surely to gosh, this is malpractice. How could something so simple become so cumbersome, right? And I looked into it and thought, well, it's really not malpractice at all. It is common practice. And this is all by procedure. And here in Tennessee, it takes 12 to 16 months for a probate estate to go from beginning to end. So it's a little more probate friendly, but because probate in Pennsylvania is a nightmare. But down here, it's not a whole lot quicker. So, you're talking about a year to a year and a half.
You're talking uncontested, easy, non-fighting,
average. Now, if the ones I've seen, I don't do probate anymore, but the fastest one I ever did when I was doing probate took about 10 months. And I don't know if the stars were just lined up right or what, but it was just kind of, and there's reasons why it takes that long. It's not just
You're
people
talking,
not
okay,
doing
so for the average person, when you talk about a probate case, you're talking about people who die with no will in place or...
Well, with a will or without a will. You're going through probate. If you have a will, by definition, you're going through probate. I like to tell people, if you don't believe me, go Google the word probate.
Now tell us what that means.
And the meaning of it is the establishing or the proving of a will. You may get the Latin version of it, vis vel del non, I think, but nonetheless, that's what it is. So if you have a will, you're going through probate. Now, if you don't have a will, the state of Tennessee writes one for you.
Okay. Then you have to go through probate.
Then you go through probate too. It's called the laws of intestate succession. Now, they've already decided who your heirs are and what percentages they're going to get. So the only difference between having a will or not having a will is if you have a will, you've got some say in where your stuff is going to go. But if you don't have a will, the state determines where it goes. And it's pretty straightforward. They look toward a surviving spouse and any descendants that you have, natural descendants, which would be children. And if you have some of them, it kind of pretty much divides up equally, unless you have a surviving spouse. And a surviving spouse gets 1/3 or up to a child share, which is kind of confusing. I've always wondered about that language. But the only time you get anything, a surviving spouse gets anything other than 1/3 is if there's only one child. Then they get half. But if there's 2 children, then the surviving spouse gets 1/3. If there's 10 children, their surviving spouse gets 1/3, and the other ones get 1/10 of 2/3.
So if you're married and you die, the spouse only gets 1/3?
Or up to a child share, which could be a half if you only have one child, without a will.
Without a will.
Yes. Now, if you have a will, typically married people's wills are what we call reciprocal wills, and say, If I pass away and my spouse is still alive, she gets everything. If she's not still alive, then everything goes to a third my 3 children, something like that. So, so the will passes everything to the spouse. But if you don't have a will, it doesn't pass everything to the spouse, which is usually not what people don't want. So if you don't have a will, or you procrastinate and don't have one, you're likely to get a result that you're not really. If you were able to arrange the result, you wouldn't have picked that. It's surprising to folks that the way that happens. And okay, that severs up property. Like, let's say the marital home. Depending on how it's titled, but if you have a piece of property in the name of the deceased, it's going to be fractional ownership.
But if the home is in both names.
Well, here's what happens with most married couples in Tennessee. I'm talking about property that may be owned solely by the deceased. But the marital home is always owned by what we call tenants by the entirety, but with right of survivorship. And what that means is at the moment of the first death with a couple, if you're a couple, bad news is one of you is going to be the surviving spouse, and
right.
one will not, right? But at the first death, all ownership vests with the survivor. So it doesn't really transfer or pass. They just inherit it. It's just all theirs, okay? But at the second death, then it has to go through probate because
right.
now it resides with that person. But I'm saying if somebody owns a piece of property just titled in the deceased name, like other than the home, because the home is the only one that automatically enjoys right of survivorship, then that gets fractional ownership among the spouse and the children for any. So I mean,
Okay.
you can come up with several results depending on the family dynamics. But like I say, the laws of intestate succession are probably not what you would pick if you had a choice to sit down and pick what you want to have happen. But if you don't have a will, that's what you get, or that's what your family gets.
But so many people just choose not to. They just choose to avoid it.
Statistically, 12% of the people have a will,
Wow.
or what we say, die testate, and the other 88% die intestate. We try to change that because we know there are actually options to wills, and they'll just trust, which is what we do a lot of. And I think trust is a better instrument than a will. Has a lot more it'll do, a lot more versatility. You can solve a lot of problems with the trust. But if I had, and I don't really like to compare the two, a will and a trust, but if they do anything the same, they both pass property after death. They both are instruments that do that.
If you do set up a trust, you still have to go through the process
Of setting it up.
Well, I mean, after people pass on, after people die.
Well, if you have a trust at death, there's a big legal difference.
So if I set up a trust for my 4 children for my inherited property, what happens after my husband and I die in a car crash?
Okay. Then the property is going to pass to the children, and your trust will say what they get. Let's just say, for simplicity, it's a fourth of everything to each child. That gets distributed, but it gets distributed under a different statutory scheme. What that means is if you pass away with property titled to you as an individual, so if your property is titled to you as Charlotte, or you and your husband, the individuals, that has to go through probate. And the reason it has to go through probate is because the property can't transfer because it's titled in the name of the deceased. So the court has to create this legal fiction called the estate of Charlotte, right? And then somebody has to step in your shoes and pass the property for you. If you pass away with it not titled to you as the individual, i.e. the trustee of your trust, now it triggers the trust code instead of the probate code. And the trust code says the trust instrument controls the distribution. And so you do go through trust administration, but it's much smoother. There's no court involvement, and it goes very rapidly. So let's just say you guys pass. We reach the second death. Now, if both you and your husband are killed in a car accident, it could be what we call a simultaneous death, where we just dictate who survived longer than the other. But eventually, we're fast forwarding through both deaths is what's happening. So if that happens, so we maybe have real estate. We got some money in the bank. The real estate, you would have named somebody in this trust that would be your successor trustee.
It should probably be someone that's not one of the 4 children.
Well, typically it's an adult child. Typically. I mean, it's a fiduciary duty. Their job is to gather the property and distribute it the way the trust says. When I say a fiduciary duty, it means they have to do what the trust says. They can't just help themselves to it, stuff like that. Now, it can be anyone. It can be anybody. It can be a friend. It can be one of the children, a sibling, or a professional. There's trust departments with banks that will take that on and stuff. So typically, though, it's people appoint a responsible adult child. And so whoever it is, that person will gather the property and look at the trust and say, okay, how is this to be distributed? So let's say we have a piece of real estate, like the house. And if you're going to say all 4 kids get a 1/4 interest in everything we have, that successor trustee will come to an attorney like me and draft the deed. And the deed will be titled like from, name one of your children's first name.
Madison.
Okay, so from Madison, successor trustee of the Charlotte's Trust, to Madison,
Kaylee, Colby, Bryson.
Yeah, to the 4 children, each a 1/4 undivided interest. And so then that asset has transferred just like that with the writing and signing of that deed. If there's money in the bank, Madison will walk into the bank and say, I'd like to take over Mom's bank account. And the bank is going to say something to the effect like, well, under what authority are you taking over your mother's bank account? And she's going to say, here's a document that says I'm the successor trustee of her trust. Here's her death certificate to show she's not here anymore. Now, the bank will recognize that immediately and say, okay, what do you want to do? She goes, well, how much is in there? Oh, exactly $200,000. Okay, so I want to write 4 checks, one to myself for $50,000, one to each of my siblings for $50,000, close the account, and walk out the door with 4 checks. And that will happen with just like that. And so it goes through what we call trust administration, which is what I'm describing with all the property. But it's not a cumbersome process. It happens quickly, and it can happen immediately after death. Most probate estates don't get open until a while after death because you have to go to court, file the petition. The court has to determine who the executor is going to be. I mean, even if you say you have an executor in your will, that's not a guarantee. It usually is if nobody else wants to throw their hat in the ring. But if somebody else says, I think I should be the executor, the court will decide. And then they swear that person in. And then finally that person now has the authority to deal with property and stuff like that. And that's usually months after death. With a trust, the successor trustee is empowered the moment of death, of the second death. And then they can start their job as soon as they want, when the mourning is over.
Right.
For you, it might be a couple of months. For me, probably a week later.
Oh, please stop it. No, so, like with our estate, there won't be any, she'll be the executor and everything, but in our situation, the house will have to be paid off. And so walk us through that process.
Sure.
Where 2 kids are at home, 2 kids are married and moved out. And so...
Any of them minors?
No.
Okay.
No minors involved.
All adult, okay.
Yeah, so the youngest is 22.
Gotcha.
And so walk us through what will happen. I'm sure this is something... The house has got lots of equity. So how do you go about taking... what I would like done is, of course, the house sold, paid off, then the kids take the profit of the house and split it 4 ways.
Oh, okay.
And then they can, move on and do what they need to do. Because there will be, a good share divided between the 4 after that's done.
Gotcha. Well, you can dictate that in the trust. And some people do. If they worry about I have some people to say, I don't want any fighting, I don't want any arguing. I want them to sell the house and divide the money. Okay. Mm-hmm. So you can put that in the trust and make it a shall. I mean, it has to be done. No discretion. You can't say, well, let's divide the house up because I'd like to keep it. You can say, we can make provisions for that if somebody actually does want the house. But nonetheless, you can say in there, I want it sold. My trustee or my executor shall sell the house and equally divide the proceeds. But the executor is empowered to do that. Okay. Now you say. Now, if there's an encumbrance on the property, like you still have a mortgage, right?
Right.
If you are a responsible person, you probably have some sort of life insurance that is designed to pay things like that off, okay? And so the executor or the successor trustee, whatever the instrument is, will make the claim on the insurance company for that money and use that money to pay off the encumbrance. Now, if you weren't selling it and dividing the money, let's say you weren't dividing the property, you can, they have the authority to either pay it off, or if there's some reason there wasn't enough money to pay it off, they can still divide the property, but of course the debt goes with it. In other words, the bank's rights are not extinguished because of this. The note is still owed, but you can still pass the property, and then it's like, okay, I inherit the house, but I also get the note that goes with it, which is an inheritance. It's just not 100%. You haven't got the whole house; you just got the equity of the house. But so and some folks are okay with that if they want to keep the real estate, because real estate in inheritance context, you either want to keep it because it's the family farm or the family home and it's sentimental, or you don't mind selling it. If you want to keep it, then we kind of do a couple extra steps to make sure that it's there for them to keep. In other words, just like I say, you have something that will step into your financial shoes at death and pay off the debt. Because, it's very, when you have a house and a mortgage, you have it for many, many years. And
Right.
Anything can happen during that time. But, if you're prudent, you have life insurance, that's, that does exactly that. It doesn't replace you, but it does replace you financially in a way. And it can sell it off. And now these people, if they do want the house or the farm, it's unencumbered when they get it. And so that's just something we can do.
Okay, so
You're smiling. So
I know because I'm in my brain. I'm trying to. The house has appreciated in value 100. I mean,
a lot.
750%.
Yeah.
Since I bought it, because it's in the middle of Franklin.
Gotcha. Well, that would do it.
One kid wants to keep the house. So how do they divide the property, but let them buy it for what it's not the value of it, but one kid, do they divide then the life insurance and let the one kid keep the house and pay the others off?
Well, let's back up just a little bit. and that is when you pose that question, I sense the underlying assumption is you're trying to be equal with the children.
Right.
Okay. Now, there's no requirement. I mean, I get that. Most people do, but there's no
Right.
requirement.
Because it's the family home they were brought up in, had the home for 25 years, and one kid does want to keep the house because of sentimental reasons.
Gotcha.
And I'm sure you face this
Sure.
because my dad has his home that I was born in 50 years ago.
Gotcha.
And he obviously, my brother lives next door and was given the family home to him. And I understand that because I don't want to get rid of the family home either, but I don't necessarily want to live there.
Gotcha.
But I see, so he has willed the family home to my brother. And I'm okay with that, even though I won't receive the house. And it was a little shocker when he did that. And not upset, but I'm like, but I won't, if, don't jive with the family, won't be in my mom's house either.
I gotcha.
So how would, as an attorney and in estate planning, what's a great way to deal with those situations?
Well, a couple of them. One might require enough assets to do it. You could say to your 4 children, okay, I leave
And they're young, so there's not.
I gotcha.
Unless our life insurance, and I meet people all the time that don't have enough life insurance. I mean, we do,
Right.
but most people are not fortunate enough to be in our situation.
Gotcha. But I mean, you could say, okay, I want to leave the house to this child that wants it. Now, if there's enough assets to offset the other 3 to make it.
No, I didn't say there was that much assets.
Well, I know what I'm saying. That's the assets need. If you want to be equal, that's a way to do it. You could say, here's the house. Everybody gets a fourth of it. But if anybody wants to sell their portion of it, we're going to enforce something called the right of first purchase. So if this one child wants it, some of the other ones wants to sell their interest, they must offer that child the first opportunity to buy it. But typically, that's at fair market value. What is a little bit cumbersome to do is say, okay, you can buy it and then dictate a price, because that price is a moving target, like you know. And if it's years later and it's very undervalued for what they're actually buying, it's going to cause some problems with the family. So it's kind of difficult to do that.
Right.
But we put that language in there a lot, so that if somebody does want it, they can purchase it from the others, or the children can reach some sort of agreement. I mean, if they could say, okay, you can have my share, but here's what you can have it for. Something, it doesn't have to be fair market value. It can be whatever they agree to, or they can even let them have it. It just, I mean, you can. There's a couple different ways to solve the problem, but sometimes, if you say buy it with fair market value, I mean, that's what they have to do. So if the one child has to buy the other 3 out, you just may not have the wherewithal to do that.
Right. I mean, if you were trying to buy that house out from the other 3 at fair market value, I mean, that child's not going to have the resources to do that.
I mean, that's pretty typical. I mean, ideally, when you deal with real estate, it's difficult to divide.
Right.
And I always say the ideal situation, you got 4 children, you own 4 pieces of property, each one's of identical value, and say, here, you get one, you get one. Yeah, it never works that way. So if you have a farm, like a family farm, and you want to divide it by drawing lines, that's not easy either, because, when you
Who gets the creek and who gets the pasture?
You've got road frontage, you got water, you
Yeah.
got mountains with trees on, or hills with trees that aren't used for much of anything. It's hard to divide it or subdivide or partition it. So just having this undivided interest in it, like a 1/3 undivided interest, is a cumbersome way to own property. But most people usually have, not the one piece, but the family home and stuff like
Right.
that. So we really need to start with, what's the end result going to be? What's the ideal end result? So in your case, the ideal end result, I think, is for them to sell it and divide the money.
Right.
But if one wants it, now it's kind of stepping outside of your ideal result, and you want to make that available, at least the option available to them. Then, the next, like I said, the next best thing would be for them to buy the other ones out. How you could, I can't think of any other way to do it that would not be sort of like weighed in favor of that child. But,
Right.
if you, from an equality standpoint. But, equality, there's no requirement for equality. Actually, if you read your scriptures, there's a thing called the patriarchal family, where all the property goes to the firstborn son. It's the birthright. Now, that may sound lopsided, but of course now he has the resources to maintain the family and keep going. And I always liked that idea, because inequality is not, comes straight from Scripture as far as in inheritance. So it's something you can do if there's a reason to do it. But most people feel like it just needs to be equal, and I get that. I feel the same way too. I got 3 children, and, but like with my kids, your kids are pretty much all here still, right?
I got one in Johnson City.
Okay, but I mean, my kids, I got one in Florida, married, has 2 children now.
Yes.
Got another one that just got married earlier this year, still nearby, but Huntsville, and I still got one at home that I'm still hopeful for. But I have this property, and I'm not, and my goal was to do exactly what I said, pass it on to my children. And I didn't inherit much of anything from my folks, and I thought, well, this business of having family land's got to start somewhere. So I guess unfortunately it's going to start with me, because I didn't inherit anything. But now I'm facing the probability that I'm not sure any of them are going to want it.
The same with Roger.
They kind of are. My son that just got married early this year has bought a place. He's in Huntsville, and he's bought a place. And my daughter's in Miami. Now, she might, but I just don't know. I don't know. And so if they don't want it, I sure don't want to make them have it.
Right.
And I know people that ask me to do that. My neighbor was one. I have a neighbor that he's got 3 kids, and none of them want his land. And not because it's wrong, anything wrong with it, they just don't want it. They don't want to continue doing what you have to do on it. And I asked him, I said, do you want these? He says, I want them to get 1/3 each, and I want to make it so they can never sell it. Never, ever, ever. And I said, well.
And that's a nightmare for people.
Yeah. If none of them want it, why do you want to make them have it? And he said, yeah, I've worked hard for it. And I talked to him at length about that, and I just couldn't. I wasn't trying to convince him, but I was just trying to see what he's doing. I said, you're saddling somebody with a piece of land they don't want. So they've got to deal with upkeep, cost, renting it or something like that. Because if they never have, but also you cannot say you can never sell it.
But I think you and I have talked about this and clouds on titles and what did we call that? I mean, it was more than just clouds on titles, because we're dealing with that here in Lawrenceburg, where I tried to purchase a piece of land, and there are conditions on some land here in Lawrenceburg.
Oh, okay.
And they put conditions on this land in 1930, where it's passed down on the land itself, where you can never sell gasoline and never sell alcohol on a piece of land ever. Yeah. And you actually have to sue, quiet title lawsuit, the owners. And it sounds nasty. It's really not nasty.
Well, you can get out of it, but it takes a lot to do it.
Right.
We refer to those as restrictive covenants.
Yes.
And so, a lot of times people will sell land and they'll say, I'll sell you these land, and it's a 20-acre plot, or I'll sell you this 100 acres, but you can't ever build more than 1 house per 10 acres or something like that. Restricted covenant. And those can either run with the owner or run with the land. Now, if they run with the owner, the covenant ends when that owner doesn't own it anymore. But when it runs with the land, like a lot of easements,
this one runs with the land.
It is kind of in perpetuity, okay, like a power line easement or something, like with TVA, or something. So, but you can address those at some point and remove them, but you got to get all the current people that have interest in the title of that. So it might either be that land or the other lands that are affected by that. You can do it by agreement. If everybody wants to get rid of it, you can make it go.
Well, this one goes with the owners that you have to go down and find all the heirs.
That's right.
And
That's
this
right.
was terrible.
And that can get to be pretty involved after just 1 or 2 generations. That can be
It was terrible.
many people.
Imagine going down to the 1930s and finding all
my
the
gosh.
heirs. It was terrible.
And if everybody does want to just get rid of it, there's always going to be one to say, "Well, is it worth anything? And how much will you pay me to?"
Right.
So, I know what you're talking about. And then there's the restricted covenants, and then there's easements, which are a little bit different.
Right.
And easements can be around for a long time. They're typically easements of necessity, which means if they have to be there, they stay there. But if they don't, you can get rid of an easement if it no longer needs to be there. If that makes sense.
Right.
Like say somebody has an easement that's across your land, and they force that. Like
To get to your property that's landlocked or something.
Yeah, right, to have access to public road. Now, they're entitled to access, but they're not entitled to whatever access they want. They're entitled to have the least obstructive access over somebody else's property. So let's say you have the property, they have the easement over it, and it's been there for a long time. Well, and later on, something happens where public road is put in, and somewhere else on this person's land, it's an easier access to get to that. The easement over your land is no longer necessary when there's a less obstructive way to do it. Or if he buys a piece of land now has road frontage, the easement goes away. Because like I say, it has to be necessary to impose on another person's property. You have the dominant estate and the servient estate, and the dominant estate, if it's not needed anymore, it'll go away. Or in my case, I bought a piece of property and there was an easement over it, just a little ways to get to it. And then a couple of years later, the person that had the easement contacted me and said he was selling, and I bought that piece of property. And so it's what they call merge. And there's no need for an easement because I now own the easement.
Okay.
I mean, I owned the property the easement was on. So it just kind of merged and goes out of existence that way. So easements can also run with the land or run with the owner. I actually was in front of the county commission in Giles County many years ago about a bridge that leads onto my property. And I wanted to do something with it, but it wasn't mine. It didn't work very well. It was a giant block of concrete, and they put a hole in the middle of it for the creek that was about 10 inches wide, like a pipe. It was about 10 inches in diameter. Well, any kind of rain, it was always 1.5 feet over top, and it was a bridge, but it was a problem every time it rained. And every little piece of debris that would come down would get stuck in a 10-inch hole.
I was going to say it clogged up.
Yeah.
Yeah.
And so, I approached them and said, I wanted to rebuild it so it would work. I mean, of course, I said it in so many ways, and they weren't too crazy about that, but they kind of said, we'll just give you that bridge, and you can do whatever you want with it. Now I'm talking about a bridge that's probably from one side to the other is probably 15 feet,
Yeah.
Or maybe 20. There's, like I said, it's just a giant block of concrete that was poured, and they put this pipe in the middle so the water could go through it. And it actually has a dip in the middle, like we know it's going to go over the top. And so there was an easement involved in that, and they just extinguished the easement because of that. So then there was another piece of property I had that my neighbor used, and when I went to the county commission about doing something with it, they said, we want to make sure your neighbor has the opportunity to use it. And so I suggested, if that's what you want, then I'm willing to have the thing exist, but run with the owner, not with the land. And so my neighbor has since deceased, and so that whatever that encumbrance was is gone away with his life.
Okay.
So they come in different varieties and different degrees, and nothing's permanent. Maybe the TVA easements are permanent, but if you got one of the big power lines, those came out in the 50s. A lot of those things, and they're all still in existence. And they can, I have one that's very close to the very end of my property, and every now and then you'll see. I'll go out there and see a bulldozer parked out there. It's like, and they travel along the line. They take down fences, bulldozer stuff, put the fences back up behind them, and cut trees and do their thing. And sometimes you'll see a helicopter with guys hanging out of it. They service the top of the towers that way.
Oh, okay, yeah.
It was interesting. My son was out there one time and he filmed it. There was a helicopter at the top of the tower, and they have a ladder. They drop down. These guys climb down the ladder and get on the tower. And the helicopter just hangs out there.
I bet they make good money.
Oh, I bet they make a lot of money.
A lot more than me and you.
For a couple of reasons, not just being from the helicopter, but you're dealing with a 151 kV line that,
That's like tower climbers that change the light bulbs on top.
But these guys scurried around like they were in my garage working on a car. You know, they didn't. I mean, they had you can see the things they hook on to stuff in case they fall. But I mean, they bounced from that tower to the helicopter and back like it was no water off a duck's back, and it was so they do it a lot. But yeah, it was pretty interesting.
So you said you work with the county commission a lot on.
No, I said I just appeared before them. I never worked.
Well,
with them.
easements and things like that. So do they ever just take the land for eminent domain for reasons like that?
Oh yeah, any government authority can do that.
And they can just take what they want?
Well, they have to show.
What's the laws on that?
Well, I'm not the best person to ask, so I'll tell you. I can relay what I do know. They have to show it's for a public purpose, and that it's necessary for a public purpose. They can't just do it willy nilly. So, classic cases are when you modify a road or widen it or reroute it or something like that, or put in a new one for that matter, like a bypass. Like we put in this bypass here. We used to have the old road 64 between Pulaski and Tennessee.
Right.
And eminent domain is when they can force the sale of it. Now they're supposed to pay fair market value for it. It's supposed to be a reasonable compensation. And sometimes it's not too bad. Sometimes it's hard to value stuff. Like if you widen the road and it's wide enough to get past what they call the setback lines and it gets into the property. What's the value of a 3-foot strip that's 250 feet long, 3 feet wide? I mean, it's a skinny little piece of land. I mean, what's the value of that? It's very hard to determine what that is, but they're required to pay for it. And so, but the problem, what it is if you don't want to give it to them, you really can't say no. If you say no, they can take it to court, and I'd say chances are probably almost 100% you won't win that battle, because unless you can prove that it's something that's they haven't satisfied their public purpose or the necessity element. So they wield a lot of power when they do that. So, but the courts will keep them from doing anything just for the heck of it. They do hold them to the necessity, but sometimes I see the necessity or the public purpose a little loose.
Right.
So, unfortunately.
All right.
So hopefully that. I've never had to deal with that personally, and I've never practiced area law, and I don't think I would want to. It doesn't sound like much fun, but
it doesn't.
Back in the early days, we were putting in railroads and everything, and expanding. That happened a lot. People got shot and killed over it. I'm sure it was very ugly. But it is a power that the government, in the good of all, that's what the power is couched under eminent domain, is that they can to help everybody. They can tread on a few, but instead of treading on them, they buy it, and that's like the next best. That's not taking it, but some people don't want to give the land up, so it's the next best thing to, taking it. It's compensating them for it.
Right. So do you see a lot of fights with your estate planning?
You mean like disgruntled heirs?
Yes.
Oh yeah. No, I don't do probate anymore, and that's when I saw most of it. I don't. Sometimes in trust administration we see some of that. Several of them have been challenged and gone to court. But yeah, a lot. So when people say, "Oh, my kids are great; they won't fight over everything," I mean, I hear people say that, and I'm not saying they will, but I'm saying it's more often they do than not.
So come see you before you get to that point.
Well, I can't keep them from fighting, but I can make sure that if you draft a trust, now I can't make such a guarantee, but if you write a trust and you decide this is what, like we were talking before, you decide this is how I want it to go. Maybe it's an unequal share. Let's just say you have 4 children, you decide to give 50% to one, 20, 20, and 10, just for whatever your reasons are. I mean, those reasons could be the one that's 10%, married a millionaire and doesn't need it, and so you just stuff like that. I mean, it could be not just trying to shortchange the child. There's a reason why. So let's say you get this unequal distribution, and now I can make the trust and make sure that that's how it will be distributed. Now, I can't keep your children from contesting it. Someone might say, well, I feel cheated. I should have got my fair share. I'm going to sue. And so they can challenge the thing. So the next best thing I can do is pretty much make it pretty guaranteed that they will not succeed. Because a trust is a very strong instrument. It's very hard to defeat. I mean, you get what you get because the maker of the trust, your intent is paramount under the law. And the courts won't disturb it unless there's some compelling evidence to do so.
Right.
And so I see it get challenged, and there's hard feelings among the family when that happens. Knockdown dragouts, I've had one case that was like that. It was just that's, you know, I often say I love what I do, but if there's one thing I don't like about what I do is when I see some of this ugliness in families. And other than that, I really do like what I do, but that can get old, and it happens from time to time. But when I don't do probate, I used to do that. That happens a lot in probate.
So what you can do in a trust is say you get a percentage of money or of the will that are not will, but things that are left at a certain age, and then at 25 you can get more and
You can do
different
that.
things.
You can do that. I mean, if you can say, okay, here's your inheritance, like my 4 kids, your 4 kids. You all get 25.
Wait, just to be clear, me and Stan do not have 4 kids together.
Oh, okay.
you said
Oh, you were talking about. I'm talking about your 4 children with your husband. I was just about to say your husband's name Stan too.
Mark, my husband Mark.
But you and Mark have 4 children.
Yes.
And so you could say, okay, all 4 of you get a fourth of what we own. Let's keep it simple. But you don't get it until you're 25 years old. Okay, now, if you pass away and some people are over that 25, well, they get it. If they're under, they have to wait for it. Or you could get a little more creative and say, okay, you get a third of what's coming your way at age 25, a third at 30, and a third at 35. Or I'm just spitballing numbers, right?
Or a third now, a third in 5 years, and a
Or
third.
in intervals, yeah, not necessarily ages, in intervals. Or you can say, what I've done on several occasions is you get a child that's what we call a spendthrift or not financially responsible.
Right.
And you say you get 10% of your inheritance a year for 10 years.
Right.
And the theory there is if you're not financially responsible by then, you're not going to be. But at least you're not going to blow it all at once.
Right.
And so it's metered out over this time. So there's all kind of whatever you want to accomplish, we can put into a trust. I mean, any terms and conditions. You can get really complicated with them, or you can be relatively straightforward. You know, or you can put it. If you really have a case that you're worried, like that the money will go in places you don't want it, you can leave it in trust for that child. Put somebody else as the trustee over it. We see that if you got a child that maybe has a drug addiction. Okay, if you have a child that has a drug addiction and you leave them an inheritance, it's very likely you're going to be the instrument of their destruction. Nobody wants that.
Right.
Because that's the way addiction works. If you're really heavily addicted to some of these, I used to see it a lot when I did criminal work, methamphetamine or cocaine. Those are highly addictive substances. And if somebody has that addiction and they come into some money, I mean, it's almost a slam dunk. That's where the money's going to go. And if they can do that, they will kill themselves with it. And so people say, I don't want to do that, but I don't want to disinherit them either because I love the child. I just don't love what they're doing. Kind of like love the sinner, but not the sin.
Right.
And so neither's a good option. Leave them the money, let them kill themselves, or just leave them nothing. So you can leave it to them in trust and give it, like maybe put one of the other siblings over it or a professional person. And it just works like this. It's like, if you want any money out of this trust, it has to be for a non-drug or alcohol purpose. So if the child says, I need $5,000 out of my trust, and the trustee says, what for? And the child says, well, I'm not going to tell you. He's going to say, well, then I'm not going to give it to you.
Right.
But if it's, I need $5,000 and I'm going to Columbia State over here and here's the tuition bill, or I'm in rehab and here's what it costs. Well, then the theory is the trustee's like, well, okay, I'll fund that because if the parents were here, they would have wanted to do that.
They would have done it.
And the trust that we leave it to them, and you and Mark, like during life, will put some guidelines in there. Is that, and you can say things like that are self-exacting and say, okay, if this happens and a period of 3 years go by and my trustee determines there's been no drug or alcohol activity and everything seems fine, then in their discretion, the trust will pretty much turn over everything to the child and make them their sole trustee of their own trust because the problem we tried to solve has now been fixed. And we can kind of reach into the future and say, if this person decides that this drug addiction just is not an issue anymore, then there's no reason for you to be the trustee over the money and monitor it. We'll just do like the rest and just pretty much turn it over to them because now it's okay to do so. And we can do that with spendthrifts, people that just blow through money, or sometimes we have people that really, really don't want their in-laws to end up with the money. So there's, we can, when it comes to making these terms and conditions, which you can only do with a trust. I mean, you can't do it with a will. I mean, you technically can, but it's a very cumbersome way to do it. But with a trust, you can put any terms and conditions in there you want. So I tell people, let's fast forward to the end and let's write down what the ideal result would be.
And then work backwards.
And then I can make that work in the language it needs to work. I just need to know what the problem is, what we're trying to solve, and what the end result was going to look like. Because you see a lot of things that, we're talking about people fighting. Sometimes we see this scenario, and it causes, although I don't know why, but it causes some family dynamics in the family, some strife, some tension, and friction. A lot of times you'll see somebody that will borrow money from mom and dad, okay? Or they'll give them a loan. Let's say they give them a loan to down payment on a house. So you have a child and he wants to buy a house. He needs $50,000 to make the down payment. You want to help. So you loan him $50,000. But you kind of take the position and say, okay, we're going to consider this an early inheritance, okay? So you can do one of two things. You can pay me back, or if something happens to me and I don't get paid back, I'm going to consider what you didn't pay back an early inheritance.
Okay.
And the way it works now is, so let's say you'll take your 4 children, you loan one of them $50,000, but then say none of it was paid back, or you just decided to have it paid back at the inheritance. What we'll do is we'll take everything you own and divide it by 3 and distribute it to the other three until each of them has $50,000. Then every dollar after that will be divided by 4. Okay, now that's called an offset. Now people can look at that and say, well, that seems unfair, but it's really not, because the person already got their $50,000
Right,
during
absolutely.
life, and so you are being equal, even though on the instrument itself it may look like it's not equal.
Well, my parents always thought that was a great idea to give us money while they're alive and not wait until they're dead
Yeah.
to give us all the money that they can.
So you enjoy your inheritance.
They can watch us have
Yeah,
it.
that's right. That's right. But some of the friction I see, and a particular case comes to mind, is that it really was a loan. They were supposed to pay it back. And when I talked to the person that was writing the trust, they pretty much told me they just ignored the loan. They never
Yeah.
made any attempt at all. And then, of course, when we put that in, and then that person actually passed away not too long after that, we were in the administration, and the heir takes the position that, well, there was never any, they said they didn't want me to pay it back. There never was a written agreement, stuff like that. And it's like, well, that doesn't matter. This is how they left it. This is the way it's going to be distributed. So they got disgruntled, went to court. And of course, they weren't successful, because anytime you get to court, and you can challenge anything. You can file a lawsuit about anything. But when you get to court, you have to be able to prove your case, right? It's all about proof. So if you get into court, then if you want to prove that you weren't supposed to pay it back, then the court's going to want to see some kind of proof. And if it's just, oh, grandma just told me she didn't want me to have to pay it back, that's not proof. And so it becomes very cumbersome for them to be successful. But when they get unhappy and then you guys are getting $50,000 more than me, and you sue the family or you sue the thing, it creates a lot of friction. Sometimes the relationship between the people is never the same, if not always.
Right.
You pull that trigger, and that's the part I hate to see. And we try so hard to keep that from happening.
Right.
But you don't know. People, unfortunately, money makes people different. I'd go so far as to say it just makes them weird.
What if you start out weird?
Well, maybe it makes you weirder, but I'm of the opinion myself. If you leave your children a big inheritance, you might not be really doing them a big favor.
So what do you do with it instead?
Well, good question.
Give it to us?
Yeah, I mean, really good question. I mean, it's a catch-22. You
really
have it,
is.
you got to give it to somebody. But maybe you just want to give it to them in a way that's just not some giant windfall, and they feel like they just don't have to do their the responsibilities of life. Be productive and be gainfully employed, or if you're not employed, contribute by having a business and doing something. I think if people get a large inheritance, they just think, well, I don't need to do that anymore. And I think that breeds a degrade in your character. You and I grew up in a different era. We probably spent every moment of since we were able to work a job, working a job.
Doing something to contribute to society.
Yeah, I mean, I can remember being like 13 or 14 years old, and nobody would hire me because I was too young. The only thing I could do was have a paper route, and I was a golf caddy. Okay, and so I did that. I did what I could, because I was trying to. You couldn't hold me down. I wanted to make money. I wanted to do stuff. I had some ideas. And then when I became 16 or something, whenever it was, when somebody would actually hire me, I had some kind of job. I've always had something going
Right.
my entire life. And I don't see that anymore. And people report that to me. So, they got a lot of people that just don't want to work anymore. Not just recently, but we've really seen it recently. But that is changing.
It is. What are the first steps that we can take right now? So you're talking about building a trust and coming to see you. What do we need to, how do we need to start?
I'd say one of the best things to do, especially if you don't know anything about it. In other words, a lot of people say, I've heard the word trust, but I don't know what it does, or I just thought a trust was for rich people that had a lot of,
That's what we hear. Trust fund kids.
And it's not, that's not the criteria at all. The ability to control the distribution after death is the main reason we do a trust. If you don't have a big estate, then it's more important it goes to the people it's supposed to go rather than be consumed in some kind of contest. So what I like to do is, I do these seminars. If you can come to a seminar, we give you the basic knowledge of a will versus trust.
And these are free.
I did. They're free educational seminars. I offer it freely. And then if you think, well, that trust sounds like a pretty good idea, then we schedule a meeting. You come see me. We talk further about it. I also have these seminars because I kind of do them every other month now rather than a little more often like I used to. I have a recorded version of them, and I can see the clock behind you, so I'm keeping up with it.
Well, something came up on my computer, and I'm like, what does it want? Okay, go ahead.
It's probably being totally unreasonable to want something. But so I have a recorded version of that I will send to people if they want to. And I kind of would really prefer that they watch that before we have an initial meeting for a couple of reasons. One, if you watch it, I won't charge you for that initial meeting because you've been pre-educated. If you're walking off the street and want 2 hours of my time, what we call a cold meeting, the gals in the front will make you pay for it. But if you have already seen the options and you're sort of leaning one direction, just want to talk about it more, then I extend that time at no cost. That's what the seminars are for, to let you know that there are options. Because usually at the seminars, you hear there's things we can do, or what you could do, and you gravitate towards one immediately and say, I didn't know that was available, and that sounds like it's a good fit for my family. I'd like to hear more about that. Seminars are only an hour to an hour and 15 minutes long, so we don't get into a deep dive. But so I do have some videos that are a deep dive into some certain things, and like I said, I have the one that I give at the seminar I give is a recorded version. I mean, it's the next best thing. I mean, live is best because you get to see me be live, but
and eat cookies.
That's right. But and we'll make that to somebody if they can't get to the seminar or would like to do it sooner. We can send that to them. So that's available. But anyway, speaking of the seminars, let me review the one that's coming up again. I don't know when the next one is. Probably going to be in January, but probably not early in January because of the holidays and all that. Probably mid to late January. But and I haven't seen the schedule for next year. The girls will work that up. But the next one that's on the calendar is coming up is November the 2nd, which is a Saturday. It's up in Franklin. And it's called Will's Trust in the Nursing Home. And that's going to be at a place called Suite 501 at 416 Mary Lindsay Polk Drive in Franklin, Tennessee. And on Saturday seminars, we always do them at 10 o'clock in the morning. And so if you want to come to that, call my office at Prochowski Estate Law, Prochowski Elder Law. The number is 931-363-7222. Or you can go to my website, which is easy to find, estateplanstand.com, and there you can get the phone number, or you can ask me a question by email, and you can call me and ask me a question about anything. The girls will schedule a call back, and I'll be happy to answer your question. Or you can email it to me, and I'll answer it that way. Or come to the seminar. You can see my calendar and see where I'm going to be when I do the public seminars like that. You'll see, and I think you can even RSVP from the website. I don't know. I'm not that techie on that stuff, but there's a way to do that. But Franklin's not a bad drive. Apparently, you drive it every day.
I used to. I'm here now.
Oh, okay.
Oh, that's a nice picture. Look at that. I'm yawning. So sorry.
Well, I guess only the people watching.
I know. I haven't had my coffee yet, and so I'm like, oh.
From time to time, I remind myself I have to be aware of that because this is visual radio.
Oh, no. So sorry. Hey,
I hope you're not yawning because of my subject
matter. I know.
Because of what I'm talking about.
No. Well, so. It's definitely one of the most useful things to listen to.
Well, I appreciate that.
It's definitely not one of my favorite topics, but it's one of the most useful topics.
It is very procrastinated. A lot of people procrastinate, and I did too.
We think we're going to live forever.
Yep.
And then...
Well, what really brings that to light is something happens to somebody and things aren't so well, and that sort of puts a flame on you in a way to maybe go do something. But don't feel bad. I've done it too. You're in good company if you procrastinate. I often tell the story that I was practicing law for like 7 years before I wrote my first will.
Oh.
And it gets worse than that. We cranked it out about 8 o'clock at night on the night before my wife and I flew off on a vacation when we left our 3 minor children with Grandma.
Well, you
so
know
we
what?
got in under the wire.
That's where we wrote our first, if something happens to us, my kids get left to.
Yep.
And we signed it and said, okay, because we know that that was at least somewhat legal binding, but not necessarily what we needed to do.
Well, it expresses your wishes, which will carry some weight after if something did happen to you.
Right. And so, because it always scared me.
Yeah.
But
that's a thought that wakes people up in the middle of the night. If I'm out on date night and we don't come home tonight, what's going to happen to my minor children?
Right.
That ought to scare you.
Because especially people who fight over whose parents are going to keep our kids, whose parents are going to get our kids.
Well, it looks like we're coming down to the last few seconds. So, again.
This is WDXE.
Bye, Stan.
So long. And W237FD Lawrenceburg. Broadcast services of Prospect Communications.
It's another day picking up the pieces from Hurricane Milton. I'm Dave Anthony, Fox News.
We're going to come back. We're not going to play the victim and lay down.
Bradenton Beach Mayor John Chappie dealing with cleanup from 2 hurricanes in 2 weeks in Florida, but he tells Fox.
So much to be grateful for. No deaths.